All right, thank you so much for staying with Daybreak. The hashtag we're using is Daybreak. You can text 22422 at Citizen TV Kenya, at Zinzi K, at Waiga Moura, at Trevor Mbija. We'd like to know what your experience has been like in the legal system and whether you think the judiciary is heading in the right track. We'll find out from you in just a bit. You can send in your tweets. But before that, let's bring in some studies here. The EACC study on corruption, the ethics in the judicial sector. This was published in 2014. The first one says that court users reported that there were delays in the delivery of judgment, documents pertaining to cases disappeared, and that there were variances in sentencing.
Especially variances that don't make sense. Okay, let's take a look at another slide which also shares some of the challenges that came out of that particular report published back in 2014. Officers in the judicial system noted ignorance of litigants, shortage of staff, corruption, case backlogs, and bureaucracy as major problems in the judicial system.
All right. And that there's still more on that. We're just going to run through them really fast. So officers in the judicial system also stated that the courts were located far. 62% court services were costly, 35%, and that people living with disabilities were not catered for. 21%, that's hindering accessibility to court services.
Maybe let's quickly run through the other two as well, just to give you a snapshot of where the country was back in 2014. How's that changed? Well, in 2019, that's what we'll find out. Meanwhile, court users mentioned constraints to accessing justice as court processes being too long, 60%, postponement of hearing, 54%, and distance to the courts, 38%. Physical distance is a challenge, Trevor, for many.
And there's still more. So the officers in the judicial system also acknowledged that the practice of payment of bribes to hide files was at 35%, hiding files as you pay, and abuse of office was at 24%, bribing the judges, prosecutors, and clerks for favorable judgment was at 19%, as forms of corruption encountered in the sector.
All right. Of course, you can weigh in on this. 2242 is our SMS line. Use the hashtag Daybreak. We don't mind if you call in. 0719 777 777. We'll display all the numbers on the screen. But Wilson, you have seen this in action. What were your frustrating moments as you went through Kenya's legal system for about 20 years? What were your most frustrating moments?
Well, if you allowed me just to...
you had one point.
Yeah, like
briefly.
Before I come to that one, I wanted to advise a colleague, Ready Women Caucus, when the laws are being passed, they should be hook-eyed, so that they are able to identify the mischief before the law is enacted. Because you know the problem with the implementation of gender law. If they were able to identify the reason why it is now a strong counter-argument against that one, then they should be able to. We understand the prehistoric injustices against women, and we want to encourage them to go ahead. We know they have the ability, but then they should be able to come in before the law is put on papers. So that is what I wanted to advise.
Even though they are saying it's not just for them, even you, where you sit, you
well, I was not here. Perhaps I would
you are not there. Okay, that's a fair.
But that is the way we should be able to go now. Be able to look at them before it is put on papers. Now, the other issue we are talking about, I agree, the system was very bad in the past. Today there is significant progress.
You have seen significant progress.
Yes, there is significant progress, sanity and good judgment, progressive judgment in the court. They are such, but we are not yet home. There's things still we are agitating for. For example, things we are talking about, the bail and board. They are used as though they are sort of punishment. Bail, according to our constitution, is a right. You should not come into court and then you are told, okay, you can apply for bail. Why? It should be credited automatically on you. Then the prosecution can start saying, no, we don't. It is the prosecution should object, but from the onset, you should be credited with the bail. The right to the bail. Okay. That one is a constitutional right. Okay. So it's not to be used as a all huge amount of money as a bail. Number two, when we are talking about a case adjournment, adjournments that are too long, like you're given 8 months. You cannot fail to conclude that it's like you're already guilty because you are serving a term. And when you are convicted, in the event you are convicted, nobody is going to come and account for this time that you've spent in prison. You know, because there is no difference between the unconvicted prisoner and those who are convicted.
Are these, and I'm sorry for putting you on the spot, if you don't mind sharing, are these things you went through personally?
Yes, I went through those things. There's no difference. When we are in prison, I'm unconvicted, there's a convicted prisoner. We are feeding the same, we are sleeping the same, we are doing, you are going through the system of a sample.
As if you've already been convicted.
Yeah, so the moment you give somebody an abnormal adjournment of 8 months and all that, it's like you've already found him.
And this time will not be accounted for.
Adjudge him guilty.
When you're sentenced later on, this time is not accounted for. Even
it is
if the
not
adjournment
accounted
goes for a year.
Yes, it is not accounted. In law, it is supposed to be accounted, but
physically,
the moment you are released, you're not going to be compensated for that. That is where I'm saying you're not going to be compensated.
So there's no compensation, and even if you're eventually convicted,
yeah, you have served those 8 months or even
no, they do that much. They
Sometimes
do. If you have served time, they'll tell you either you get this less for time served, or sometimes you'll be told, okay, your sentence is the time served. So that is really accounted for. But the point I think Wilson is making is that nobody is making up for the loss of income you've had, the loss of time with your family. That time is literally lost.
It's gone.
Yeah,
but in sentencing, that is a factor. The time you've served in remand.
Yes, in the event you are released, it is lost that way, that and you already served the term in prison.
You've already,
okay. So again, when you are talking about, cherry picking parts of the law and implementing, judiciary has also part to blame. You know, because judiciary deals with the interpretation of the law. They're the people who are supposed to ensure that the law gives equal protection to every person. And with the example that I started giving here, you can be able to see that it is the judiciary that is supposed to ensure that the law is applied to every person. Those sexy laws should be sexy to everybody. The hostile laws should be hostile to every person.
What a way to put it.
That's what we are saying.
The
judiciary, yes. The judiciary should be able to ensure that.
Okay.
Yeah, and we can be able to see this disparity when the cases appear in court.
All right, let's bring in Harriet on this. From the Law Society of Kenya angle, how do you ensure that the common mwananchi is not really oppressed, so to speak, by the law, and it applies equally to everyone?
That is very important, and when you look at Article 49 of the Constitution, it actually gives provisions of bail. And this is the current issue that we've been having, especially when we are dealing with these corruption cases. You'll find that each and every citizen, and the Constitution is very clear, that bail has to be affordable. Now, the debate has been there for a very long time, and you'll realize, and when we were here earlier, Wahiga, when we started this debate on access to justice, the big question was, who are we arraigning in court? Are they the real culprits? You know, the big question then we ask is, have we already judged them before we take them through the legal process? And already we can see where all these cases are going. They are all frustrated. Currently, as we speak, they are all they are all going almost nowhere, you know. And the common mwananchi has to be protected for sure, using the legislation that is in place, because you'll find quite a number of them appear in court not because they are the real culprits, but they are a front of the real culprits. And that is why most of these cases are actually going nowhere, you know. That
is why most of these cases are not going
and they
anywhere.
will go nowhere, because we took these cases to the court to the public court for Kenyans now to make that decision, to debate upon them, to castigate the persons who are in court. But in the real sense, what kind of cases were these that we are presenting before this court?
In your stint now as Vice President of the LSK for how many months? A year and some time, right?
Yeah.
What are the biggest complaints that your office has received from members of the public in terms of access to justice?
Basically, it's the court access and the delays in court. And you'll realize that in most cases, first, the courts are highly constrained in terms of human resources. This is one thing that has to be improved going forward. The next thing that the courts must look into, and this is more or less inward in terms of the institutions, is corruption. We cannot say there's no corruption in the corridors of justice, you know.
So you admit that far, that there is corruption?
Definitely.
So
you see,
and is it more of corruption to get a favorable verdict, or corruption to make sure files don't disappear? Is it corruption through the journey, or at the very end where you are now told if you want a favorable verdict, you must?
I'll even take you back, and so that for you to realize the corruption in the judiciary is actually a chain link cutting across board. During CJ Mutunga's time, remember he had a fraud, he had a stint with the judicial clerks on the kind of receipts that were being issued. Last year, you saw quite a number of law firms were listed in terms of certain amounts of money not being paid. The question then is it the law firms or is it the clerks working in the law firms and the clerks at the judiciary and the banks? Explain to me how I make payment through a bank account. But when it comes to reconciliation, it is nowhere to be traced.
The money cannot be found.
The money cannot be traced. So where is this collision? Is it within the clerks at the law firms? And not, it's the law firms being flagged. The law firms, not the clerks, because it's the clerks who actually do these payments in these registries. So you find there's a big chain. When it starts with the clerks, to the clerks of the courts, to even the banks, because you cannot do this without an officer at the banking hall. Yep. And then take it back now to the chambers itself. Who are these who take this money? Who are these? How does this money move? In most cases, you'll also realize some of these magistrates are not even aware that their names are being used to collect this money until when you give an unfavorable judgment and somebody is on you with a gun. Yeah. So it's a whole chain link that has to be cracked. Okay. You know, and I'm glad that CJ Mutunga is actually speaking about this, because it then means we are ready to correct.
Okay. Yeah. Wilson, I'll come to you later on, but Kakai, there's a court in Nyeri that sentenced a woman who had banged worth 2,820 shillings to 30 years in jail. Yeah, so would you say that the law is applying equally here? In as much as there's one argument that she was a repeat offender, she was trafficking, but people are wondering, this would not happen to someone who's of a higher caliber, for example, like a governor, for example.
Before I answer that question, I want to take ourselves back to what you really actually brought up from the beginning, that based on that reporting the issues of access to justice. And then I'll answer your question. One is that access to justice has been with Kenyans for many years. And I want to class it into two categories. Access to justice, the way we saw it prior to 2010 Constitution, and access to justice post-2010 Constitution, so that we put it into context of what you actually raised in that report. And when you read that report, it actually touches on the very key issues that we should be discussing or debating on access to justice. In a nutshell, prior to 2010, we had very many challenges in terms of access to justice, when you talk about access to justice generally. And you realized that Kenyans were sick and tired of issues around access to justice. Lawyers came out in public, churches came up in public, human rights activists came up in public, and then we all documented all that. And that time I was a beneficiary because I was in civil society. Actually, I was leading an organization in civil society. So we know what we went through. And we said for us to solve this issue of access to justice, we must transform access to justice to read as it follows. So we've had gaps, we have had challenges. So there are also good things we've done as Kenyans, and there are also bad things. So what do? Post-2010 Constitution, we came up with very specific articles that deal with issues of access to justice and how we deal with them. Article 48, for example, Article 22 of the Constitution, and the broad overview of the Constitution talks about how can we ensure that every Kenyan actually access to justice. And what's access to justice to an ordinary mwananchi? One, am I able to go to court? The short distances we are talking about. Am I able to go to court? To court, exactly, and get my case solved? Am I going to travel 100 kilometers to reach a judicial system? Then if that's the case, I will not go. Am I able to go and file my case in a court of law and be heard and given an opinion as soon as possible? If not, I will not go. So we have had all those challenges. But the good news is that the post-2010 Constitution has tried to solve these issues. When you look, for example, the criminal justice system and, for example, the judiciary, before they never used to have so many high courts. Right now, the judiciary must be priding of itself of having more than 47 high courts, meaning they are trying to bring closer justice to close to people. How many magistrate courts does the judiciary have right now? They probably have about 119 magistrate courts, meaning that they have tried to spread as many as they can, and almost in every county. That is what we call now access to justice. I have reduced the distances of people from moving very far to go and seek justice. For example, sometimes back, a litigant will move from Lodwar to Kitale because the highest court was in the highest, the High Court was in Kitale. For you to move from Lodwar to Kitale, is that access to justice? No, it's not access to justice. What has the 2010 Constitution done? Brought a High Court closer to the people in Lodwar. So we must also talk about the gains as a country that we've done as Kenyans in terms of improving access to justice.
Although that is physical access to justice.
Yes,
but
I'm also coming to the issue of legal. I'm also coming to the issue of legal and financial. It was very difficult before to litigate, even to hire a lawyer and even to pay court filing fees before. Right now, if you have a matter of public importance or interest, what does the Constitution say? Is that almost like filing fee will be free. You are able to access, as long as you prove that this is matters of public interest, filing fee is almost free. Is that now access to justice in terms of financial? Yes, it is access to justice. Why is it access to justice? It's because now you are able to litigate. When you see Okia Mtata going to court in almost every case, those are now what we call public interest litigation. They have been made so easy in the current constitution for you to litigate. In terms of filing fees, it used to be very prohibitive. Right now, it's a little bit cheaper.
So you've seen progress.
We have progress, and we must also talk about the gains we've attained. We must also talk about the challenges that we have. Maybe the institutions have taken a longer term in terms of short-term gains, which we are seeing. Long-term gains are different issues. Now, when it comes to the question you asked, in terms of what does the law say? The law says that justice is equal to everybody. So whether you are poor, whether you are rich, and my colleague has talked about it, the same justice applies to everybody. Sentencing, Joy will talk in details about how sentencing is done because she served as a magistrate for many years. But as a lawyer, if, for example, that Nyeri lady was tasked and was told to pay X amount of fine, that is what the law said. So you can't isolate one item because I don't know the circumstances under which the court came and ruled on that. I don't know what offense it was, but you can't isolate one item and say that it's prohibitive to the poor because you class them as the poor and it's cheap for the rich. No, the law is the same. The law applies the same. It all depends on how a magistrate now is looking at that kind of evidence before the magistrate and then meeting that judgment.
And then meeting that judgment. So even as you come in, they say that in a just and fair society, it's not the poor that can drive, but everyone is comfortable using public transport. That's how you have equalization of sorts. It's one thing to have a progressive constitution, but at the end of the day, when a person who earns $1 or lives on $1 a day, can that person afford a lawyer, which is an integral part of the legal system? Are we there yet? To really say that, you know, I mean, he's saying access to justice has been made easier, court fees have been brought down, but can the average Kenyan really afford to keep a lawyer on payroll for a month, 2 months, 3 months?
No, of course not.
And if they can't, what are the options?
Of course they can't, because as Ms. Harriet pointed out earlier, litigation is very expensive. And part of that expense is lawyers' fees. I mean, you've seen part of our accusation for corruption is we use fee notes as ways of siphoning money. Because, I mean, lawyers can charge a pretty penny for their time. However, I must agree with what Kissinger is saying. Access to justice has been vastly improved. And he would know about it because he served under Chief Justice Mutunga. And they did a lot of work in making access to justice, not just about the physical court being nearer, but also demystifying. He had this thing he used to call demystifying the judiciary. So he did a lot of demystifying, yes.
Okay.
He did a lot of demystifying the judiciary. And so you find many people are a lot more aware about their rights, what they can get, what they cannot get. And they're not bolder. That's why you find we are a lot more litigious society. However, today, me and the legislature, we are here today. However, look at this particular instance that you're pointing out, the woman in Nyeri. If you read the Narcotics Act, the sentences, msokoto moja wa bangi, is absolute ridiculousness. It's really, really high. It's really, really punitive. And it's one of those things that are supposed to be mandatory. You shall sentence like this. You shall sentence like this. The other one that was recently in the spotlight, the Sexual Offences Act, same thing. So you write something. We are fighting against the war against drugs. So you write a law that has got very heavy, very punitive provisions to try and deal with these particular matters. Same thing with sexual offenses. At the end of the day, by the time you realize that what you're actually meting out is injustice rather than justice, the train has left the station. That now brings me to the issue of with the law. We have to have a systemic and very intentional push at enabling those people supposed to change the law do it. the Law Reform Commission, they need to be given the capacity to be able to routinely look at these laws and say, this is past time. Because in as much as these ones are excessive, we have some other things that you look at the fine and it's ridiculous. You're told, by the way, for not doing this, the fine is 1,000 bob. And you're like, this is a much weightier offense. Okay. Why is it so low? So our law reform systems need to be revamped, need to be more deliberate. The Law Reform Commission needs more enabling. Same thing with the legislature. We need to stop this writing laws for NGOs, because some of these acts are drafted by NGOs. I would know, because I've been in civil society. There are times you can actually draft a bill and push it through Parliament, and you end up with an NGO bill with, you know, something that is not in congruence with what is happening in society.